Now, today's a big day. The Supreme Court will begin to decide if Boris Johnson was right to shut down Parliament. So just how serious could this be for the Prime Minister? Well, to talk us through the events that will be unfolding here in the studio, Raphael Hogarth, an associate at the Institute for Government. Raphael, good morning to you.
Morning.
Put it into context. In the legal world, how big is today?
I think it's a very big day. This is a big constitutional case. I don't think constitutional lawyers have been this excited since the Article 50 litigation over whether the government could kick off the Brexit process without legislation authorising it to do so from Parliament. I think there are sort of very big constitutional ideas being litigated at the Supreme Court this week. We all know that Parliament is sovereign in the UK Constitution, but I think one of the questions that the Supreme Court is being asked to give a view on now is what does that sovereignty really mean? Does it only mean that when Parliament makes laws, those laws have to be observed and can't be questioned? Or does it actually mean more than that? Does it mean that Parliament has to have meaningful opportunities to legislate and even to scrutinise the government at times like this one, where the government is doing something against an Article 50 ticking clock?
Just to remind people how we got there was a ruling in the High Court in England that Boris Johnson's move to suspend Parliament was lawful. In Scotland, it was ruled unlawful. The Supreme Court, if you like, has the final say today. What kind of evidence will they be considering? Well,
I think there are two issues the Supreme Court's going to be looking at. So the first issue they're going to be looking at is whether this is justiciable at all. So that means, are there legal standards which the court can apply in order to judge whether Boris Johnson's decision to advise the Queen to prorogue was legitimate or not?
So should they get involved at all?
Exactly.
Okay.
And the High Court in England said no, and the Court of Session in Scotland said yes. And then the second issue that they're going to be looking at is if it is justiciable, if the courts can properly reach a view on that, then was that decision to advise the Queen to prorogue legal or not, constitutional or not? And essentially, in order to answer that question, they need to look at, well, what was the Prime Minister's purpose in advising the Queen to prorogue? And was that purpose an improper purpose or a proper purpose? On the one hand, the government says it was a perfectly proper purpose, which was to usher in a new legislative agenda with a new Queen's speech. But the challengers say it was an improper purpose, which was to evade parliamentary scrutiny of and possibly opposition to the government's Brexit policy. How can they determine the thinking that went into it? Because there was a lot of controversy last week when it was decided that,
Boris Johnson and his advisers wouldn't hand over personal communications about the thought process and the planning that went into the suspension of Parliament. Would that evidence be key? And what happens if the Supreme Court don't have access to something as vital as that and as telling as that?
Well, it's a little bit procedurally knotty because what Boris Johnson's motives were is ultimately not a question of law, it's a question of fact. And so normally the Supreme Court wouldn't actually decide questions of fact. It would accept whatever findings of fact were made in the courts below. And the Court of Session made a finding of fact on that, which was that Boris Johnson's purpose was to avoid parliamentary scrutiny. And you ask, what evidence did it use to reach that view? Well, it saw various minutes of government meetings, it saw some advice to the Prime Minister and his scribblings on that advice from his officials, and of course it's also got all of his statements in public and the statements of his ministers to look at. So ordinarily the Supreme Court wouldn't question that factual finding, but because of the really uncharted constitutional waters we're in, the huge significance of this case, they might, in that sense, ignore the rule book and look at that issue themselves.
Well, it's so knotty. It's not all going to be done and dusted in a day. We're expecting a ruling either on... oh, look, there's the Hulk. Is that Boris Johnson? He's described himself as the Hulk. I think he's got more important things to be doing today than protesting outside the Supreme Court. There he is, the Incredible Hulk there. That's, of course, what Boris Johnson called himself. Sorry to interrupt that. That just caught my eye there, Raphael. But just finally, the Supreme Court, we're expecting a ruling towards the end of this week, maybe Monday. Is there room for appeal? Can it be appealed, whatever decision is made by the Supreme Court?
No, the Supreme Court's word is final. The only thing that can happen after the Supreme Court has said what the law is to change that is that Parliament can legislate. But as far as the court's view goes, the Supreme Court has the final word.
OK, Raphael Hogarth, Associate at the Institute for Government, thank you very much for giving us your point of view. Raphael there with a guest appearance from The Incredible Hulk. British Politics Day. You never know what's going to happen.